Case 1, Gina Emmanuel, Miami-Dade County. Case 1, Gina Emmanuel, Miami-Dade County, Florida. A licensed registered nurse adopts 3 children. One of them dies. That is where this case begins, and it ends with a life sentence handed down in a Miami-Dade courtroom on April 30th, 2025. Gina Emmanuel was 56 years old at the time of her conviction. She held an active Florida registered nurse license. In 2017, she completed the legal adoption of 3 sisters. The children were 12, 7, and 6 years of age at the time of the adoption. The 7-year-old, identified in court documents by the name Samaya, became the center of the criminal prosecution. In late 2018, Samaya became severely ill. Emmanuel, despite holding a professional nursing license and possessing clinical training in the recognition and treatment of medical emergencies, did not seek timely medical attention for the child. The Miami-Dade Medical Examiner's Office conducted a forensic autopsy following the child's death. The medical examiner's findings, which were introduced as evidence at trial, established that the 7-year-old child's cause of death was pneumonia and sepsis secondary to medical neglect. The 7-year-old child died. Following the child's death, the Florida Department of Children and Families and the Miami-Dade Police Department opened parallel investigations. Investigators conducted forensic interviews with the 2 surviving sisters using child forensic interview protocols administered at a certified child advocacy center. Those interviews produced disclosures of an ongoing pattern of physical abuse and neglect directed at all 3 children throughout their time in Emmanuel's home. The conduct documented in court records included forced confinement, denial of food and water, the use of physical restraints, burns to the hands, and the requirement that the children consume human waste as a form of punishment. These disclosures were corroborated through forensic medical examinations of the surviving children conducted by medical professionals trained in the evaluation of physical abuse. Emmanuel was arrested in 2019. The Miami-Dade County Circuit Court set her bond at $120,000 and ordered that she have no contact with the surviving children. She was charged with 1 count of first-degree murder in connection with the death of Samaya and 2 counts of aggravated child abuse with great bodily harm in connection with the conduct directed at the 2 surviving sisters. The prosecution theory for the first-degree murder charge was premised on felony murder, specifically that aggravated child abuse, a recognized predicate felony under Florida Statute 782.04, caused the death of the child, thereby satisfying the statutory requirements for a first-degree murder conviction without requiring proof of premeditation. The case did not proceed to trial until early 2025, approximately 6 years after the arrest. The delay was attributable to the complexity of the forensic evidence, the number of investigative agencies involved, and standard pretrial procedural timelines in first-degree murder cases in Miami-Dade County. The State Attorney's Office for the 11th Judicial Circuit of Florida, under State Attorney Katherine Fernandez Rundle, prosecuted the case. The jury trial included testimony from the 2 surviving sisters, whose accounts of the conditions in Emmanuel's home formed a central component of the state's evidentiary presentation. According to coverage by WPLG Local 10 News and CBS Miami, the surviving sisters provided sustained, detailed testimony regarding the pattern of conduct they had experienced and witnessed during their time living with Emmanuel. The jury also heard from forensic medical experts who testified regarding the autopsy findings and regarding the physical examination findings for the surviving children. On April 15, 2025, the jury returned a verdict of guilty on all 3 counts: first-degree murder and both counts of aggravated child abuse with great bodily harm. Sentencing was conducted on April 30, 2025, before Miami-Dade County Circuit Judge Christina Miranda. Judge Miranda sentenced Emmanuel to life in prison without the possibility of parole on the first-degree murder count, and to 2 30-year terms of imprisonment on the aggravated child abuse counts, ordered to run concurrently with the life sentence. Miami-Dade State Attorney Katherine Fernandez Rundle issued a written statement following the verdict, specifically recognizing the testimony of the surviving sisters. At the sentencing hearing, the older surviving sister, Ayanna Gordon, then 18 years old, addressed the court directly. According to courtroom reporting by Local 10 News and CBS Miami, Gordon informed the court that she was moving forward with her life, that she intended to graduate from high school and pursue a degree in business administration, and that she had words for Emmanuel that she delivered without reservation. The defense announced an intention to appeal the conviction following sentencing. Florida law provides a direct right of appeal in first-degree murder cases to the appropriate district court of appeal, with potential further review by the Florida Supreme Court on qualifying legal issues. As of the date of this documentary, any appellate proceedings remain pending or unresolved. The Florida Department of Health Board of Nursing permanently revoked Emmanuel's registered nursing license following the conviction. Florida adoption law also provides for the termination of adoptive parental rights in cases of abuse and homicide, and the surviving children were placed under the protection of the Florida Department of Children and Families. The Florida Department of Children and Families subsequently conducted an internal review of the adoption file, examining whether the pre-adoption home study and post-adoption monitoring protocols had been correctly applied. The case has been cited in legislative testimony before the Florida legislature as a basis for extending post-adoption welfare monitoring beyond the legal completion of the adoption. It has also been cited in training materials developed for Florida adoption caseworkers regarding home visits and welfare check protocols. The Emmanuel case is one of the most significant nurse criminal prosecutions in Florida history, precisely because the defendant's professional credentials that created a presumption of clinical competence and caregiving capacity, operated alongside conduct that investigators documented as the systematic abuse of 3 vulnerable children. The case illustrates a critical principle of Florida law. A licensed nurse's professional duty of care does not exist only in a clinical setting. Where the nurse has assumed a formal legal responsibility for a dependent person's welfare, that duty follows them. The failure to meet that duty, when it causes the death of the person in their care, can support a first-degree murder prosecution. The investigative procedures used in this case, forensic autopsy, child advocacy center interviews, forensic medical examination of survivors, and medical record review, represent the full application of Florida's child abuse investigation protocol to a case in which the perpetrator held both a professional license and legal custody of the victims. The convergence of those two roles was central to prosecution's theory and to the jury's verdict. Case 2, Hiram Bonilla, Citrus County. Case 2, Hiram Antonio Bonilla, Citrus County, Florida. A patient is admitted to the hospital after fainting at work. She is 67 years old. She is placed in a private room in the emergency department. A nurse enters that room 28 times in 4 hours. Within 2 weeks, that nurse is under arrest. Within 1 year, he is convicted. Within 3 years, a Florida civil jury awards his patient $25 million in damages. Hiram Antonio Bonilla was a registered nurse licensed in the state of Florida since the year 2002. At the time of the offense, he was 57 years old and resided in Tampa, Hillsborough County. He was assigned to the night shift at Citrus Memorial Hospital, which now operates under the name HCA Florida Citrus Hospital, located on West Highland Boulevard in Inverness, Citrus County. The patient at the center of this case was a 67-year-old woman named Lena Ray. Ray was admitted to the hospital in early January of 2021 after experiencing a fainting episode at her workplace, attributable to a low hemoglobin count. She was placed in a private emergency department room for observation and treatment. Her physician ordered intravenous morphine for pain management. Bonilla first made contact with Ms. Ray during a routine medication administration on January 5, 2021. Investigators later reviewed hospital security camera footage that documented the frequency and pattern of his subsequent room entries. The footage showed that Bonilla entered Ms. Ray's room 28 times over a 4-hour period, with an average interval between entries of approximately 9 minutes. The arrest affidavit documented that Bonilla covered the room's window during these entries, obscuring the interior from staff in the corridor. Investigators determined through the forensic and testimonial record that Bonilla committed multiple acts of sexual battery against Ms. Ray during these entries. Ray was receiving repeated intravenous morphinas that had been administered at Bonilla's request, which affected her ability to respond. Ms. Ray first reported the incident to her personal therapist by telephone in the early morning hours of January 6th. The therapist immediately contacted Citrus Memorial Hospital at approximately 2 o'clock in the morning. According to the subsequent civil complaint filed in Citrus County Circuit Court, hospital officials waited approximately 6 hours before contacting the Citrus County Sheriff's Office, with the call placed at approximately 8 o'clock and 7 minutes in the morning. During that 6-hour window, housekeeping staff removed the bedding from Ms. Ray's room and reset the room to standard conditions, actions that the civil complaint characterized as resulting in the loss of physical evidence. Despite the delayed institutional response, Forensic evidence was preserved through a sexual assault evidence collection kit administered to Ms. Ray at a separate medical facility. Laboratory analysis of the collected samples identified Bonilla's DNA. Investigators also recovered verbal admissions during a recorded interview with Citrus County Sheriff's Office detectives, in which Bonilla confirmed that he had engaged in sexual acts with the patient. Bonilla was arrested on January 11, 2021, in Tampa by Hillsborough County Sheriff's Office deputies acting on a warrant issued through the State Attorney's Office for the 5th Judicial Circuit of Florida. The charges included 2 counts of lewd or lascivious battery on an elderly or disabled person and 1 count of lewd or lascivious molestation of an elderly or disabled person, all felony charges under Florida law. On March 4, 2021, the Florida Department of Health issued an order of emergency restriction against Bonilla's registered nursing license. The order stated that Bonilla had abused his position as a nurse and was unable to meet the minimal standards of acceptable and prevailing nursing practice. The criminal trial proceeded in Citrus County Circuit Court before Circuit Judge Richard Howard. Assistant State Attorney Tara Hartman prosecuted the matter for the state of Florida and confirmed publicly that the state would not extend any plea offers following her interview with the victim. The case proceeded to a jury trial in January of 2022. The jury returned a guilty verdict in approximately 45 minutes on all counts. Judge Howard sentenced Bonilla to 20 years in the Florida Department of Corrections. The civil litigation produced equally significant consequences. Ray filed suit against HCA Florida Citrus Hospital and its corporate parent, alleging premises liability, negligent supervision, negligent hiring, intentional infliction of emotional distress, false imprisonment, and allegations related to the post-incident institutional conduct. The civil complaint documented that the hospital had prior knowledge of additional complaints involving other male nursing staff at the facility. In September of 2024, a Citrus County civil jury awarded Ms. Ray $25 million, $5 million for past damages and $20 million for future damages. HCA Florida Citrus Hospital subsequently reached a confidential settlement with the plaintiff. NBC News, in an investigative report published on November 18, 2024, used the Bonilla case as a primary example in a broader examination of sexual assault inside American hospitals. The same report cited a 2023 Joint Commission study finding that incidents of assault, rape, sexual assault, and homicide inside hospitals had increased approximately 77% over the prior 2 years, based on facility self-reported data. The Florida Department of Health permanently revoked Bonilla's registered nursing license following his conviction. The case has been incorporated into nursing ethics curricula at multiple Florida nursing schools and into Florida Hospital Association advisory materials on mandatory reporting obligations. The 6-hour institutional delay in contacting law enforcement was treated as a central element of the civil negligence claim, and the $25 million verdict reflected in part the jury's assessment of that institutional failure. The Bonilla prosecution stands as a documented example of how physical DNA evidence, hospital surveillance footage, pharmacy and medication administration records, and a defendant's own recorded admissions can converge to support a sexual battery conviction against a licensed healthcare professional, even in circumstances in which institutional actors failed to preserve all available physical evidence in the immediate aftermath of the reported offense. Case 3, Mark Misker, Citrus County Case 3, Mark Misker, Citrus County, Florida. Same hospital, different nurse. 4 months before Hiram Bonilla entered Lena Ray's room, another registered nurse at the same facility had already been arrested for sexually battering a patient. His name is Mark Misker, and his case is documented as a confirmed Florida criminal conviction with a 65-month prison sentence. Mark Misker was 64 years old at the time of his arrest and resided in Homosassa, Florida. He was employed as a registered nurse at Citrus Memorial Hospital, the same facility later renamed HCA Florida Citrus Hospital at the time of the offense. The underlying incident was reported to the Citrus County Sheriff's Office on September 14, 2020. The incident itself is documented as having occurred on or about September 11, 2020. The patient in this matter was an adult female who had been admitted to the hospital for medical treatment. According to the Citrus County Sheriff's Office, Misker entered the patient's room while conducting a medication administration and committed an act of sexual battery against her during that encounter. The investigation was assigned to the Citrus County Sheriff's Office Special Victims Unit, led in this matter by Detective Arnold. The Special Victims Unit is a dedicated investigative bureau within the Sheriff's Office responsible for sexual battery cases, child abuse investigations, and crimes against vulnerable adults. The unit's standard protocol for a hospital-based sexual battery report includes immediate preservation of surveillance footage from corridor cameras and room entry points, coordination with hospital security and risk management, review of electronic medication administration records to establish the timeline of nurse-patient contact, administration of a sexual assault evidence collection kit to the patient as soon as practically possible, and parallel notification to the Florida Department of Health's Medical Quality Assurance Division, so that administrative license review can be initiated concurrently with the criminal investigation. During Detective Arnold's interview with Misgar following the patient's complaint, Misgar made admissions to the conduct alleged by the patient. The arrest affidavit documents that Misgar acknowledged the sexual battery during that recorded interview. He was placed under arrest for sexual battery. His initial bond was set at $10,000. Citrus County Sheriff Mike Prendergast issued a public statement following the arrest. The statement noted that medical professionals hold an oath to provide care and do no harm, and that Misgar's conduct represented a betrayal of his patient, his colleagues, and the broader community served by the facility. The case proceeded through Citrus County Circuit Court within the 5th Judicial Circuit of Florida. According to reporting by NBC News dated November 18, 2024, Misgar was, at the time of that report, serving a 65-month sentence, approximately 5 years and 5 months in prison, for the sexual battery conviction. The specific procedural disposition of the case, including whether it resolved by plea or by jury verdict and the identity of the sentencing judge, is recorded in the official docket maintained by the Citrus County Clerk of Courts. What makes the Misgar prosecution particularly significant in the context of this documentary is its relationship to the Bonilla case examined in Case 2. Both incidents occurred at the same facility within a 4-month window. The civil complaint later filed by Lena Ray's legal team against HCA Florida Citrus Hospital specifically alleged that the hospital had prior knowledge of additional sexual assault allegations involving Misgar dating back as far as 2016, several years before his September 2020 arrest. That allegation, if established by the civil evidence, would indicate that the hospital had received multiple complaints over a period of approximately 4 years without taking effective action to remove Misgar from patient contact. The hospital's legal defense position in the related civil matter was that the sexual battery of a patient by a nurse falls outside the scope of the nurse's employment, and therefore does not support vicarious liability under the doctrine of respondeat superior. That doctrine limits an employer's liability to acts that employees commit within the scope of their employment duties. The argument that a sexual battery was not within the scope of a nurse's employment was accepted by some courts and rejected by others, and it was ultimately contested at trial in the Ray civil case, which resulted in the $25 million verdict. Following the completion of his prison sentence, Misgar is subject to mandatory sex offender registration requirements under Florida Statute 943.0435. That statute requires registered sex offenders to comply with ongoing reporting obligations, residency restrictions, and employment prohibitions that remain in effect for specified periods following release from custody. The Misgar case, viewed alongside the Bonilla case at the same facility, illustrates the investigative principle that prosecutors and civil attorneys now refer to as the institutional pattern model. Under that model, a single nurse criminal case at a healthcare facility is treated by investigators not as an isolated incident, but as a potential indicator of a broader institutional failure, whether in hiring, supervision, credentialing review, or patient complaint handling. The institutional pattern model, when applied to the record at Citrus Memorial Hospital, generated the documentary evidence that ultimately supported the multi-million-dollar civil verdict in the Ray case, and prompted the Florida Board of Nursing to initiate administrative review of the facility's reporting practices. The forensic and procedural techniques used in the Misgar investigation are now standard across Florida hospital-based sexual battery cases. Electronic medication administration records provide an auditable log of every time a nurse accesses a medication cabinet or enters a patient's clinical record, establishing a documented timeline of nurse-patient contact that can be compared against surveillance footage. Sexual assault evidence collection kits administered promptly following a complaint provide the biological material for DNA comparison. Recorded investigative interviews with the suspect, when they produce admissions, provide the most direct evidence available. In the Misconduct case, all three categories converged to produce a criminal conviction carrying a sentence of 5 years and 5 months in state custody. Case 4, Eric Brewer, Polk County and Tampa Bay Area. Case 4, Eric Brewer, Polk County and the Tampa Bay Area, Florida. A 30-year-old registered nurse works at 5 hospitals in the Tampa Bay area over a period of approximately 3 months. At each one, he diverts fentanyl from patients who are receiving it for post-operative or acute pain management. He replaces the diverted volume with saline solution, returns the IV bag to the patient's treatment line, and continues his shift. He does this 7 documented times across 5 separate facilities before he is caught on September 12, 2023. Not by an audit, not by a pharmacy review, but because he offers to change an IV bag for a patient who is not assigned to him, disappears into a hospital restroom, and emerges visibly impaired. Eric Brewer was 30 years old at the time of his sentencing and resided in Lakeland, Polk County, Florida. He was a Florida licensed registered nurse, working as a contracted nurse at 5 hospitals in the Tampa Bay area during the period of June through September of 2023. The federal investigation that followed his discovery documented 7 distinct diversion events occurring between June 2nd and September 12th of 2023. The federal charge against Brewer was filed under the Consumer Product Tampering Statute, Title 18 of the United States Code, Section 1365. That statute makes it a federal felony to tamper with a consumer product, which includes prescription medication in an intravenous format, with reckless disregard for the risk that another person will be placed in danger of death or bodily injury. The statute carries a maximum penalty of 10 years in federal prison. Brewer was additionally charged with obtaining a controlled substance by fraud under federal narcotics law. The documented methodology of Brewer's diversion scheme, as described in the plea agreement and sentencing memorandum filed in the United States District Court for the Middle District of Florida, was consistent across all 7 documented events. Brewer would obtain needles, syringes, and saline flushes from hospital supply areas. He would identify a patient who was not assigned to him but who was receiving intravenous fentanyl. He would enter that patient's treatment room, redirect a portion of the fentanyl into a styrofoam cup or a separate syringe, replace the diverted volume with saline solution, and return the IV bag or syringe to its position in the patient's treatment line. On September 12, 2023, at one of the Tampa Bay area hospitals, Brewer offered to change the fentanyl IV drip bag for another nurse's patient, an action that other staff recognized as atypical since the patient was not assigned to him. He obtained a 100-milliliter fentanyl IV bag from the secured medication locker, connected the bag to the patient's IV line, and then entered a hospital restroom. When Brewer emerged from the restroom, observing staff noted that he was stumbling, slurring his speech, and appearing to fall asleep. Hospital security conducted a search of the restroom and recovered a bloody needle and a paper towel. Hospital management requested that Brewer submit to an immediate drug test. Brewer refused. He was terminated from his position that same day. The hospital reported the incident to 2 investigative agencies, the United States Food and Drug Administration's Office of Criminal Investigations and the Pasco Sheriff's Office. Those 2 agencies jointly conducted the subsequent federal investigation. Laboratory testing conducted on the 100-milliliter fentanyl IV bag that Brewer had connected to the patient that morning confirmed that fentanyl had been removed from the bag and that the remaining contents were diluted by approximately 50% with saline solution. The 50% dilution finding was central to the proof of the tampering charge. The federal grand jury returned an indictment against Brewer in the Middle District of Florida. He entered a plea of guilty on April 28, 2025. The plea agreement included a factual admission that Brewer had acted with reckless disregard for the risk that patients would be in danger of death or bodily injury and under circumstances manifesting extreme indifference to such risk. Language drawn directly from the statutory text of the Federal Consumer Product Tampering Statute. On August 8, 2025, United States District Judge Stephen D. Merryday sentenced Brewer to 5 years and 3 months in federal prison, followed by a term of supervised release. The case was prosecuted by Assistant United States Attorney Greg Pizzo of the Middle District of Florida. The investigative agencies of record were the FDA's Office of Criminal Investigations and the Pasco Sheriff's Office. The significance of the Brewer prosecution within the Florida nurse criminal case landscape is substantial. First, it represents the application of federal consumer product tampering law to a registered nurse's diversion conduct. a prosecutorial framework that carries considerably more severe consequences than state-level controlled substance theft charges. Second, it demonstrates the forensic capability of modern laboratory analysis to confirm the dilution of intravenous medications with sufficient precision to support a federal criminal conviction. Third, it documents a pattern of diversion across 5 separate healthcare facilities, illustrating the capacity of a contracted nurse to move between employment placements without triggering interdependent detection systems at any individual facility. The FDA's Office of Criminal Investigations has expanded its investigative presence in healthcare-related diversion cases involving injectable controlled substances over the past 5 years. The Brewer case, alongside comparable Florida prosecutions of Jerome Clampett II in Jacksonville and Katherine G. Rankin in Jacksonville Beach, establishes a documented federal enforcement pattern for this category of offense. The Florida Department of Health Board of Nursing initiated emergency administrative action against Brewer's registered nursing license following his termination in September of 2023. Under Florida Statute 464.018, a felony drug conviction involving the practice of nursing is a statutory basis for permanent license revocation by the Board of Nursing. Hospital risk management literature has cited the Brewer case as an example of the role of behavioral observation in detecting diversion on an active shift. The combination of an unsolicited offer to handle another nurse's patient, a brief unexplained absence, and visible signs of impairment following that absence constituted a sufficient behavioral signature for hospital management to act quickly. The 7-event pattern across 5 facilities over 3 months, however, illustrates that this behavioral signature was not recognized at any of the 4 prior facilities at which Brewer worked, a finding that has prompted updated inter-facility information sharing protocols in the Tampa Bay healthcare community. Case 5, Katherine G. Rankin, Duval County, Florida. A registered nurse is confronted by her supervisor at a Jacksonville surgical center for forging an anesthesia record. She is terminated on the spot. She does not leave immediately. Instead, she is captured on the facility's surveillance cameras, removing vials from the controlled substances cabinet. Then, before she walks out of the building, she tells 3 of her colleagues exactly what she has been doing, hands them 4 vials she has already tampered with, and explains precisely how she tampered with them. That conversation, those vials, and that surveillance footage become the foundation of a federal criminal prosecution. Katherine G. Rankin was 30 years old at the time of her arrest and resided in Jacksonville Beach, Florida. She was a Florida licensed registered nurse employed at a surgical center in Jacksonville, Duval County. The events leading to her prosecution began on October 13, 2022. On that date, a supervisor at the surgical center reviewed records and determined that Rankin had forged an anesthesia record. The supervisor confronted Rankin and terminated her employment during that confrontation. Following her termination, Rankin remained inside the facility. Surveillance camera footage captured by the surgical center's internal camera system documented Rankin removing vials from the controlled substances cabinet in the period immediately following her termination. Before exiting the building, Rankin approached 3 other employees and engaged them in a direct conversation. According to the plea agreement filed in the United States District Court for the Middle District of Florida, Jacksonville Division, Rankin told those 3 colleagues that she had an addiction, that she had been taking controlled substances from the facility, and that the facility's drug count was going to be off. She then handed the 3 employees 4 vials of injectable hydromorphone, and she explained what she had done to those vials. Rankin told the employees that each vial no longer contained hydromorphone. She stated that she had removed the hydromorphone from each vial, replaced the volume with saline solution, glued the caps back onto the vials, and returned them to the surgical center's inventory so that the controlled substance count would appear to balance. Forensic laboratory testing conducted after the vials were handed over confirmed Rankin's admissions in full. Each of the 4 vials showed evidence of physical tampering, specifically that the caps had been removed and reattached using adhesive, and chemical tampering, specifically that the contents of each vial consisted of substantially diluted hydromorphone and saline rather than the labeled concentration of hydromorphone. The investigation extended to the surgical center's patient records. A detailed review identified numerous patient records in which the documented volume of hydromorphone administered was listed as 200 milliliters, when 100 milliliters would have been the standard administered dose. In those records, the notation appeared to have been physically altered. The numeral 1 had been overwritten with the numeral 2. Additional records reflected hydromorphone administrations with no corresponding clinical indication in the patient's treatment plan. The case was investigated by the United States Food and Drug Administration's Office of Criminal Investigations and the Jacksonville Sheriff's Office Pharmaceutical Diversion and Designer Drug Unit, which operates as part of the North Florida High-Intensity Drug Trafficking Area Task Force, a federally funded multi-agency investigative body administered by the Office of National Drug Control Policy. The prosecution was handled by Assistant United States Attorney Michael J. Coolican of the Middle District of Florida. Rankin entered a plea of guilty in federal court to one count of tampering with a consumer product, specifically injectable hydromorphone, in violation of Title 18 of the United States Code, Section 1365, subsection A, paragraph 4. The maximum statutory penalty for the offense is 10 years in federal prison. The plea agreement included a factual admission that, as a trained and educated healthcare professional, Rankin was aware that tampering with controlled substance medications and falsifying related medical records placed patients at risk of bodily injury and potentially death. The forensic methodology used to detect the physical tampering of the vials in the Rankin case has been incorporated into subsequent Drug Enforcement Administration training materials for field investigators examining suspected healthcare diversion. The physical indicators of vial tampering that investigators are trained to identify include glue residue around the cap seating area, irregularities in the cap's alignment relative to the vial body, and inconsistencies in the printed lot number alignment. The consistency of these physical indicators across all 4 recovered vials in Rankin's case allowed investigators to establish a documented pattern of systematic tampering rather than a single incident anomaly. The patient harm implications of diluted hydromorphone in a surgical center setting are clinically significant. Hydromorphone is a Schedule II controlled substance prescribed for moderate to severe pain. Patients at an ambulatory surgical center receiving diluted hydromorphone would experience inadequate pain control during and after surgical procedures, a failure of clinical care that cannot be detected by standard vital signs monitoring in the absence of an active pharmacy audit. Ambulatory surgical centers in Florida operate under regulatory authority of the Florida Agency for Healthcare Administration, but their pharmacy operations are generally smaller and subject to fewer layered audit controls than those at full-service hospitals. The Rankin case has been cited in Florida Agency for Healthcare Administration regulatory guidance as a basis for enhanced pharmacy reconciliation requirements at ambulatory surgical centers. The Florida Department of Health Board of Nursing issued an order of emergency restriction against Rankin's registered nursing license following her termination from the surgical center, pending formal administrative proceedings. The Board of Nursing's standard disposition in federal consumer product tampering cases involving a nurse is the initiation of a formal administrative complaint resulting in permanent license revocation following the federal conviction. Case 6, Leah Ann Parra, Palm Beach County, Florida. A patient is admitted to the intensive care unit. Her mother is sitting in the room with her. A nurse enters. The mother watches. What the mother sees next leads directly to the nurse's arrest and to a pharmacy audit that confirms the diversion had been happening for longer than anyone initially realized. Leah Ann Parra was 40 years old at the time of her arrest and resided in Palm Beach Gardens, Florida. She was employed as a registered nurse in the intensive care unit at HCA Florida JFK Hospital, located in Atlantis, Palm Beach County. The investigation was conducted by the Atlantis Police Department. According to the probable cause affidavit filed in the case, the events leading to Parra's arrest began on August 23, 2024. The mother of an intensive care unit patient was present in her daughter's hospital room when Parra entered, stating that she was there to check medication levels. The patient's mother observed Parra use a syringe to remove fentanyl from a vial that was connected to her daughter's intravenous line. She then observed Parra use a second syringe to add a clear liquid back into the same vial. The patient's mother immediately reported what she had observed to another registered nurse on the intensive care unit floor. That nurse examined the fentanyl vial and observed multiple puncture marks in the vial's rubber stopper, a quantity of punctures far exceeding what would be consistent with a single or even multiple legitimate medication administrations. The witnessing nurse notified hospital administration. Hospital administration confronted Parra. According to the arrest report, Parra initially denied any wrongdoing. Hospital officials then requested permission to search Parra's personal bag. Parra consented to the search. During that search, the hospital security director discovered additional syringes, multiple vials of lorazepam, and multiple vials of diphenhydramine inside Para's bag. Following the discovery, hospital administration advised Para that the matter would be reported to law enforcement and to the Florida Board of Nursing. At that point, Para admitted to the theft and to tampering with the patient's fentanyl vial. According to the arrest report, Para stated that she wanted to seek help for her addiction and that she intended to self-report to the Florida Board of Nursing. The arrest report further documents that Para acknowledged diverting controlled substances both directly from patient vials and from the hospital's secured medication locker. The hospital's pharmacy director conducted an internal medication reconciliation review following the incident. According to the arrest affidavit, the pharmacy director confirmed that the amounts of controlled substance recorded in the hospital's reconciliation records did not align with the amounts that should have been on hand for the period during which Para had been working. That discrepancy corroborated the investigative theory that the diversion had been ongoing prior to the August 23rd incident. As a part of the investigation, Para voluntarily provided urine and blood samples for laboratory analysis. Atlanta's Police Chief Robert Mangold confirmed in a public statement that the laboratory results were consistent with the conclusion that Para had been using diverted controlled substances. Chief Mangold specifically noted that the hospital's prompt institutional response had been instrumental in preventing the diversion from affecting additional patients. Para was charged with grand theft of a controlled substance, possession of a controlled substance without a valid prescription, and possession of drug paraphernalia, all felony offenses under Florida law. She was arrested at the hospital and subsequently released on bond. HCA Florida JFK Hospital terminated her employment and issued a public statement through spokesperson Catherine Walton confirming that the hospital had notified the Drug Enforcement Administration, local law enforcement, and the Florida Board of Nursing. The Florida Department of Health initiated administrative proceedings against Para's registered nursing license. The Board of Nursing's standard procedure in diversion cases is to pursue license suspension or revocation following a criminal conviction or following an administrative finding of impairment affecting the nurse's capacity to practice safely. The Para case is the first of two documented cases occurring in 2024 involving registered nurses at HCA Florida facilities in Southeast Florida who diverted or diluted controlled substances intended for patients. A related prosecution of Nicole Sprutenberg, a registered nurse at HCA Florida Lawnwood Hospital in Fort Pierce, was reported by CBS 12 News in November of 2025. Sprutenberg was charged with 13 counts of possession of a controlled substance without a prescription and 13 counts of grand theft of a controlled substance. She told investigators she had diluted patient medication with saline. The pharmacy supervisor at HCA Florida Lawnwood confirmed to investigators that the stated methodology was not consistent with any recognized clinical practice at that facility. The Para case illustrates three recurring investigative principles in Florida nurse diversion cases. First, family member witnesses play an increasingly significant role in the detection of diversion at the point of patient care. Second, physical evidence from the medication itself, specifically the puncture mark pattern on the vial's rubber stopper, can establish a visual record of repeated unauthorized access without requiring laboratory testing. Third, pharmacy-level reconciliation review provides a second-tier audit function that can confirm whether a diversion extended beyond the single observed incident. All three categories of evidence were present and operative in the Para matter. Case 7, Gay Gall, Sumter County, Florida. An 87-year-old woman with dementia falls in the common area of an assisted living facility. A licensed practical nurse is on duty. The nurse does not assess her, does not chart the fall, does not notify the physician, does not notify the family, directs a certified nursing assistant to put the resident to bed. The resident is found deceased in that bed the following morning. The nurse is charged with a felony. Gay Gall was 71 years old at the time of her arrest and resided in Spruce Creek South, Summerfield, Florida. She held a Florida licensed practical nurse credential and was employed at Freedom Point Assisted Living, which operates under the Brookdale Senior Living corporate structure and is located within the Sumter County retirement community of the Villages. The underlying incident occurred on July 17, 2020. According to the Sumter County Sheriff's Office arrest report, the 87-year-old resident, a female with a documented dementia diagnosis, was seated in a common area of the facility when she experienced a fall. Under Florida Agency for Healthcare Administration regulations, and under Brookdale Senior Living's internal clinical policies. The standard protocol following any resident fall in a Florida assisted living facility requires immediate neurological assessment, immediate vital signs assessment, physician notification, and family notification. These requirements exist regardless of whether the resident appears to have sustained an obvious injury. Because head injuries resulting from falls can cause internal neurological damage that is not externally visible at the time of the fall. None of these protocol steps were followed by Gall. According to the arrest report, Gall directed a certified nursing assistant to move the resident to her room and put her to bed. The certified nursing assistant expressed concern about the direction, noting that the resident appeared unresponsive and appeared to require medical attention. Despite that contemporaneous concern, Gall did not personally assess the resident, did not initiate a clinical evaluation, did not contact the resident's attending physician, and did not contact the resident's family. Gall also failed to document the fall in the resident's medical record, a separate violation of nursing documentation standards that is independently required under both Florida Agency for Health Care Administration regulations and standard nursing practice guidelines. The resident was found deceased in her bed on the morning of July 18, 2020. The Sumter County Sheriff's Office investigation determined that the resident had died at some point during the prior afternoon or evening. The medical examiner's autopsy findings, which established the causal relationship between the fall and the resident's death, were a critical component of the subsequent criminal case because they provided the forensic documentation of the causal link between Gall's omissions and the resident's death. In her recorded interview with Sumter County Sheriff's Office detectives, Gall acknowledged that she had failed to perform any of the required post-fall assessment duties. She admitted specifically that she had not performed neurological checks, had not taken vital signs following the fall, had not contacted the attending physician, had not contacted the family, and had not documented the fall in the resident's medical record. Gall was terminated from Freedom Point Assisted Living following the investigation. The Sumter County Sheriff's Office, in coordination with the State Attorney's Office for the 5th Judicial Circuit of Florida, arrested Gall and charged her with 1 count of neglect of an elderly or disabled adult under Florida Statute 825.102, a felony offense. The case proceeded through Sumter County Court. Gall entered a plea of guilty during the final week of April of 2021. Pursuant to the plea agreement, the court sentenced Gall to 3 years of probation. The Florida Department of Health initiated administrative proceedings against Gall's licensed practical nurse credential following the conviction. Under Florida Statute 464.018, a felony conviction involving the practice of nursing is a statutory basis for license suspension or revocation. The Gall case is significant within this documentary for several reasons that extend beyond the individual facts. First, it represents a documented Florida felony conviction, premised entirely on an omission, the failure to provide required care, rather than an affirmative act of harm. Florida's elder neglect statute, which is codified at Florida Statute 825.102, explicitly encompasses both acts and omissions when the omission constitutes a willful or culpable failure to provide the care necessary to maintain the physical or mental health of a vulnerable adult. The Gall prosecution establishes that post-fall assessment obligations imposed on unlicensed nurses in Florida assisted living facilities are legally enforceable through the criminal justice system. Second, the certified nursing assistant's documented contemporaneous concern, expressed to Gall directly on the day of the incident, and later documented in statements to investigators, was central to the prosecution's case. That concern established that Gall had been specifically alerted to the resident's apparent condition and had nonetheless failed to act. Without that documented contemporaneous witness, establishing the element of willful or culpable neglect would have been more difficult for the state. Third, the Gall case has been used in subsequent civil litigation against Brookdale Senior Living and in Florida Agency for Health Care Administration enforcement actions as a reference point for the criminal consequences that can follow from a failure to implement post-fall protocols. The case is one of several that has prompted Brookdale Senior Living to review its post-fall training curriculum and documentation requirements across its Florida facility portfolio. Case 8, Getty Belazaire, Brevard County, Florida. It is December 13, 2018. Overnight shift. A certified nurse at an assisted living facility in Melbourne, Florida, disappears from her station. Her coworkers notice. They begin searching the facility. They find her. What they discover leads to a forensic DNA investigation, a felony arrest, and a Brevard County prosecution that took months of laboratory analysis to support. Getty Belizaire was 34 years old at the time of her arrest. She was a certified nurse employed at the Brookshire Nursing Assisted Living Facility in Melbourne, Florida, located in Brevard County. The facility serves residents with a range of cognitive and physical conditions. The patient at the center of this case was a male resident who had received dual diagnoses of dementia and Alzheimer's disease. On the night of December 13, 2018, co-workers of Belizaire noted that she had been absent from her assigned station for approximately 90 minutes, a significant and unusual deviation from standard overnight shift behavior. The co-workers searched the facility and located Belizaire in the bathroom of the male patient's private room. According to the staff who discovered her, Belizaire was partially without clothing at the time she was found. The patient appeared distraught and disoriented. The patient communicated to responding law enforcement officers that Belizaire had committed a sexual act against him. While the patient's dual diagnoses of dementia and Alzheimer's disease meant that he had substantial cognitive limitations, his account was sufficiently consistent to initiate a formal criminal investigation. The Melbourne Police Department was contacted. Standard Florida sexual battery investigation protocol was applied. The patient was transported to a hospital-based medical facility, where a sexual assault evidence collection kit was administered. The kit collected biological samples for laboratory analysis. Belizaire was interviewed by Melbourne Police Department officers at the scene. According to the arrest report, she stated that she had never been in the patient's room. That statement was directly contradicted by the testimony of the co-workers who had found her in the patient's bathroom, partially unclothed at the time of the discovery. As part of the investigation, Belizaire consented to a buccal DNA swab, a sample collected from the interior of her cheek, which was submitted to a forensic laboratory for comparison with the biological material collected during the patient's sexual assault evidence collection kit examination. The Brookshire Nursing Assisted Living Facility terminated Belizaire's employment on December 14, 2018, the day following the incident. The Florida Department of Health initiated administrative review of her nursing credential. The forensic laboratory analysis required several months to complete. DNA comparison results were received on March 25, 2019, and confirmed the presence of biological material consistent with sexual contact between Belizaire and the patient. On April 8, 2019, Belizaire was arrested and charged with 2 felony offenses under Florida law: lewd and lascivious molestation of an elderly person and abuse of an elderly person. She was booked into the Brevard County Jail with bond set at $10,000. The Brevard County State Attorney's Office, operating within the 18th Judicial Circuit of Florida, accepted the case for prosecution. The Belizaire case illustrates several forensic and investigative principles that are directly relevant to the prosecution of abuse cases in institutional settings with cognitively impaired victims. A patient with both dementia and Alzheimer's disease will typically have a substantially limited capacity to provide reliable testimony that withstands cross-examination. Florida prosecutors in cases involving cognitively impaired victims therefore rely heavily on physical forensic evidence, witness testimony from staff, and the consistency of the victim's own account, even when that account is limited by the victim's cognitive condition. The DNA confirmation in the Belizaire case provided the physical corroboration necessary to support the felony charges in the absence of fully reliable testimonial evidence from the victim. The role of co-worker observation in detecting the offense is equally significant. Belizaire's co-workers identified an abnormal behavioral pattern, 90 minutes of unexplained absence from her assigned station, and responded by conducting an active search of the facility. Their decision to search and their immediate recognition of the situation upon finding Belizaire in the patient's bathroom constituted the first response evidence that triggered the entire investigative chain. The Belizaire case has been cited in Florida assisted living facility regulatory literature as an example of the importance of overnight shift supervision, station visibility protocols, and staff location accountability systems. Florida Agency for Healthcare Administration inspection reports across multiple assisted living brands have cited overnight staffing visibility as a recurring area of concern, and the Belizaire prosecution has been referenced in those reports as a documented consequence of inadequate supervision during overnight hours. Case 9, Nia Nayers, Osceola County, Florida. The patient is 18 years old. She has cerebral palsy. She is nonverbal and quadriplegic. She cannot speak. She cannot call for help. She cannot physically resist. The home health nurse who has been assigned to care for her is the only other person in the room. There are no colleagues watching, no supervisors present. What happens in that room is only discovered because the patient's mother installed surveillance cameras. Nia Nayers was 24 years old at the time of her arrest and had been employed as a home health nurse since 2021. The patient at the center of this case was an 18-year-old female resident of St. Cloud, Osceola County, Florida. The patient's conditions, cerebral palsy, nonverbal status, and quadriplegia, meant that she had no independent capacity to report, resist, or communicate the conduct directed at her. In early May of 2025, the patient's mother noted explained physical marks around her daughter's mouth and on her eyelids. She also observed what she interpreted as a behavioral change in her daughter. The family had previously installed home surveillance cameras as a precautionary measure given their daughter's complete dependence on external caregivers. The patient's mother reviewed the surveillance camera footage. The footage documented Ayers engaged in a pattern of conduct directed at the patient during caregiver visits. According to the St. Cloud Police Department's investigative findings, the conduct documented on the footage included repeatedly applying adhesive tape to the patient's mouth and forcefully removing it, holding a washcloth against the patient's mouth, and manually shaking the patient's mechanical breathing assistance device while it was connected to the patient through a nasal interface. The patient's mother brought the surveillance footage to the St. Cloud Police Department, which launched an immediate investigation. The investigative steps included forensic review and preservation of the home surveillance footage, an interview with the patient's mother, a review of the patient's medical records to document her cerebral palsy diagnosis and the clinical basis for her nonverbal and quadriplegic status, and an identification of all healthcare agencies through which Ayers had been employed. The St. Cloud Police Department also issued a public request for any other families who had received care from Ayers through any healthcare agency to contact the department, and an investigative practice known as victim outreach, used when evidence of a pattern of conduct may extend beyond the documented single incident. Ayers turned herself in to the St. Cloud Police Department on May 7, 2025. She was charged with one count of aggravated abuse of a disabled adult under Florida Statute 825.02, subsection 2, paragraph C. That subsection establishes aggravated abuse of an elderly person or disabled adult as a first-degree felony when the defendant knowingly or willfully commits acts that cause great bodily harm, permanent disability, or permanent disfigurement to a person who qualifies as elderly or disabled under the statute. The maximum penalty for a first-degree felony under Florida law is 30 years in state prison. Ayers was booked into the Osceola County Jail and held without bond following her initial appearance. The Florida Department of Health initiated emergency administrative action against her nursing credential. At the time of her arrest, Ayers' credential had been active since 2021 and carried no prior complaints or disciplinary notations. St. Cloud Police Chief Douglas Girk issued a public statement characterizing the conduct documented on the surveillance footage as one for which there was no available defense, given the patient's complete inability to resist or communicate. Both healthcare agencies through which Ayers had been employed were notified of the arrest. Under Florida law, healthcare agencies are required to terminate the employment of a nurse charged with aggravated abuse of a disabled person pending the resolution of the criminal case, and to report the matter to the Florida Department of Health. The case has been incorporated into home health agency training programs addressing background screening, supervisory visit protocols, and the operational value of family-installed surveillance in home care settings. The policy significance of the Ayers case extends substantially beyond its individual facts. Home health nursing presents a structural supervisory gap that institutional nursing does not. A nurse providing care in a private residence is, by definition, outside the continuous observation network that exists in hospitals and nursing facilities. Florida Agency for Healthcare Administration regulations govern home health agencies and require periodic supervisory visits, but those visits do not provide real-time oversight during patient care encounters. The Ayers case has generated sustained advocacy by patient rights organizations for expanded surveillance requirements or caregiver-present monitoring technology in home settings where the patient is nonverbal and physically unable to report or resist. The Ayers prosecution illustrates the principle established in Florida law that the complete inability of a victim to report or resist is not a mitigating factor in a criminal sentencing context. It is an aggravating one. The first-degree felony classification of aggravated abuse of a disabled adult under Florida Statute 825.102 reflects a legislative determination that the most dependent and most vulnerable patient populations require the most robust legal protection. Case 10, Christina Hyson, Linda Moore, Christopher Rodriguez Lozada, Orange County, Florida. 3 licensed registered nurses, 1 patient, 1 night in September of 2019. The patient has hypothermia, a clinical emergency requiring warmed intravenous fluids, warming blankets, and continuous temperature monitoring under physician order. What the 3 nurses do instead causes injuries that require multiple surgical procedures to address. What makes this case unusual is that it takes 2 years to result in arrests, and that all 3 defendants are charged on the same day. The facility is Select Specialty Hospital Orlando North, a long-term acute care hospital located in the metro Orlando area of Orange County. The patient was a disabled adult who, at the time of the events in question, was experiencing hypothermia, a condition in which the body's core temperature falls to a clinically dangerous level. In a hospital setting, the recognized treatment for hypothermia includes the administration of warmed intravenous fluids pursuant to a physician's order, the application of commercial warming blankets, and continuous monitoring of the patient's core temperature until it returns to the normal range. According to the investigation conducted by Florida Attorney General Ashley Moody's Medicaid Fraud Control Unit, which was announced in an official press release on August 13, 2021, the 3 defendants, Hyson, Moore, and Rodriguez Lozada, all licensed Florida registered nurses, responded to the patient's hypothermia by filling ice bags with hot water drawn from a coffee maker with a hot water dispenser function and applying those bags to the patient's body. This methodology is not a recognized clinical intervention for hypothermia and is not taught in any accredited nursing program in Florida or elsewhere. It is directly contrary to established hospital protocol at Select Specialty Hospital Orlando North. After applying the hot water-filled bags, the 3 nurses left the patient unattended. According to the investigation, the patient remained without assessment for at least 2 hours. Another employee then discovered the patient and observed that the patient had sustained multiple third-degree thermal injuries. Third-degree burns affect the full thickness of the skin and the underlying tissue structures and require specialized wound care and typically surgical intervention, including skin graft procedures. The patient was transferred to Orlando Regional Medical Center, where the patient underwent multiple skin graft surgeries to address the thermal injuries. The patient survived. The investigation was conducted by Florida Attorney General Ashley Moody's Medicaid Fraud Control Unit in coordination with the Orange County Sheriff's Office and the Groveland Police Department. As part of the investigation, law enforcement obtained and reviewed the employment and training files for each of the 3 defendants. The records confirmed that each defendant had received a 2-hour pre-service orientation training on resident rights, a standard training program provided to healthcare workers before they begin patient-facing duties, and designed to ensure familiarity with the basic legal and ethical obligations owed to patients in care settings. The arrests of Hyson, Moore, and Rodriguez Lozada were announced simultaneously on August 13, 2021. Approximately 2 years after the underlying events of September 2019. Each defendant was charged with 1 count of aggravated abuse of a disabled adult, a first-degree felony under Florida Statute 825.102, and 1 count of neglect of a disabled adult, a second-degree felony under the same statute. The combined maximum exposure for each defendant, if convicted on both counts, was up to 45 years in state prison and fines of up to $20,000. Florida Attorney General Ashley Moody issued a written public statement upon the announcement of charges. The statement confirmed that the patient had sustained injuries requiring multiple surgical procedures as a direct result of the defendant's conduct, and that the Office of the Attorney General would continue to investigate and prosecute the abuse of vulnerable Floridians in care settings. The case was referred to the Office of the State Attorney for the 9th Judicial Circuit of Florida, the circuit that serves Orange and Osceola counties, for prosecution. The 2-year gap between the underlying incident and the arrests is attributable to the investigative methodology applied by the Medicaid Fraud Control Unit, which conducted a detailed review of clinical documentation, employment records, training records, and physical evidence related to the thermal injuries before presenting its findings to prosecutors. The forensic reconstruction of thermal injuries is a specialized area of medical investigation. The temperature of the fluid source, The volume and insulating capacity of the container used, the duration of contact with the patient's skin, and the burn pattern itself are all quantifiable data points that forensic burn specialists can analyze to establish the mechanism and timing of the injury. That reconstructive capability was central to building a case that could support first-degree felony charges 2 full years after the underlying event. The Medicaid Fraud Control Unit's involvement in a patient abuse case, as opposed to a billing fraud case, reflects the full scope of that unit's statutory authority. Under Title 42 of the United States Code, Medicaid fraud control units are authorized to investigate patient abuse and neglect in any facility that receives Medicaid funding, regardless of whether the specific patient involved in a given case was a Medicaid beneficiary. The Select Specialty Hospital Orlando North facility received Medicaid funding, establishing the jurisdictional basis for the unit's investigation. The Hyson, Moore, and Rodriguez-Lozada prosecution illustrates a principle that several of the cases in this documentary address. Under Florida law, aggravated abuse of a disabled adult does not require proof of malicious intent in the traditional criminal law sense. The statute requires only proof of knowing or willful conduct that causes great bodily harm to a person who qualifies as elderly or disabled. The third-degree burn sustained by the patient, in this case, injuries requiring multiple skin graft surgeries, constituted great bodily harm under the statutory definition, and the defendant's conduct in applying hot water-filled bags to the patient's body and then leaving the patient unattended for 2 hours satisfied the statutory elements of knowing or willful conduct. The case has been incorporated into training programs for nurses and nursing leaders across Florida hospital systems as a documented example of why deviation from established clinical protocol carries criminal exposure for the individual nurses involved. Regardless of whether the deviation was intended to help the patient, whether the deviation was initiated by one nurse or by a group, and whether any nurse who participated subsequently attempted to deny involvement. 10 cases, 10 Florida counties, 10 prosecutions that moved through circuit courts, federal district courts, state attorney offices, and administrative license proceedings. The evidence in these cases included forensic DNA analysis, home surveillance camera footage, hospital security camera records, pharmacy reconciliation audits, laboratory testing of intravenous medication bags, medical examiner autopsy findings, and defendant admissions recorded during law enforcement interviews. The sentences in these 10 cases ranged from 3 years of probation in Sumter County to life in prison without the possibility of parole in Miami-Dade County. The civil consequences reached $25 million in a single Palm Beach civil award. The federal consequences included 5-year sentences in federal custody. The administrative consequences included permanent revocation of registered nursing licenses by the Florida Board of Nursing. What each of these cases has in common is not a single type of conduct. They involve sexual battery, medication diversion, patient neglect, child abuse, aggravated physical harm, and institutional cover-up. What they share is the structure of accountability, a licensed professional in a position of trust, a patient who was vulnerable and in need of care, and an investigative and prosecutorial system that, however slowly in some cases, identified the conduct, built a case, and secured a legal outcome. The nursing profession in Florida consists of hundreds of thousands of licensed professionals who provide essential care to some of the most vulnerable people in this state every single day. The cases documented here represent a small fraction of that profession, but they are documented, they are verified, and they are the cases this channel exists to examine. If this documentary provided value to you, tap the like button. Leave a comment. Which case do you think raised the most significant questions about Florida's healthcare oversight system? The Bonilla verdict in Citrus County, the Emmanuel life sentence in Miami-Dade, the Brewer federal prosecution across 5 Tampa Bay hospitals, the Ayers surveillance footage in Osceola County. Tell us in the comments. And if you are not already subscribed to Hidden Case Diaries, subscribe now. We cover verified criminal cases through the lens of investigation, forensics, and court procedure. Every case, every fact, documented. This is Hidden Case Diaries. See you in the next case file.